I'm going to start off with asking you, what did you do after law school? And
Okay.
so,
That's easy.
yeah, I know. You ready? Okay. So let's get started. And what happened after you completed your law school training?
I returned to Norfolk. I learned that none of the bar review courses that were operating in Virginia would admit any blacks to their program. And there were, I think there was one in William and Mary, there was one in someplace in northern Virginia, Alexandria, another one out in the Charlottesville area, but none of them would admit blacks. The people or the person who ran this course at William and Mary would sell you a copy of his law review notes. And this was what black graduates who wanted to take the bar, this was about the only route, well, the practical route. You bought a copy of the notes, which I did. And I began to study them and talking with practicing lawyers here and so forth. And in due time, I took the December 1950 bar exam. They have one twice a year. One in June was out in Roanoke, and the one in December was in Richmond. And I had no desire to go to Roanoke, and I wasn't ready for the June exam. So I took the one in Richmond. And there were a lot of people there. And I saw some people who were from Norfolk. These were white law students. They had gone to, of course they hadn't gone to Howard, but any of it, I saw them there and recognized them, talked to some of them, got their names, so that when the bar list was published of those who had passed, why, I recognized several of these people on this list. So I took the bar exam in December. The results came out in February of 1951. Fortunately, my name was on the list, and I passed.
So were a number of the other people you recognized during the exams, were their names on the list?
Oh yes, and I can even recall one or two right now whose names were on the list and who began practicing just about the time I did.
Who were those individuals?
Oh dear. Well, one was a lawyer, his last name is Bright. And unfortunately, I can't recall his first name at the moment, but a few years later, he lost his license because he was convicted in federal court of a criminal charge. And he was sentenced to, I don't know, 10 years or something like that. And he subsequently served his time and was released, but he's never been able to get his license back. And he had two sons. And by the time this unfortunate occasion happened, his sons were grown. They had graduated from law school and were with him in the same law firm that he had. And they had about 4 or 5 or 6 lawyers in the firm. But nobody else in the firm was implicated in the charges for which he was convicted. He was a good lawyer too, very good lawyer. Very nice guy too. Any event, and some of the others, they have either retired or died. I just, at the moment, don't recall any of the names, but I remember him because he was very good.
So what did you do in the interim between finishing law school, preparing for the bar, and then taking the bar? What did you do in the interim?
Well, I worked in my father's office. My father was a licensed real estate broker, and he had a business, and a small real estate business. He also, in addition to representing buyers or sellers, he represented property owners. That is to say, he would be their agent and rent their property and see that it was maintained and that type of thing. Management, in other words. He was also a licensed casualty insurance agent. He didn't sell any life or health insurance, but he sold casualty insurance. And so he had an office, and I helped out and did what I could in that office. At that point, I wasn't licensed. I subsequently became licensed as a real estate salesman and as a person qualified to sell casualty insurance, but at that time I wasn't.
So after you successfully passed the bar, what happened after that?
Well, of course, in preparation, I talked with other lawyers in the area, minority lawyers, because none of the majority law firms would hire any minority. None of the public agencies, like the city attorney, the Commonwealth's attorney, or for that matter, the state attorney general's office, or the United States attorneys, none of these areas and others where they hired lawyers. The Corps of Engineers has a small staff of lawyers here, but none of them would hire any blacks. So that was not a possibility. But I talked with the black lawyers, and the only office where there were more than a single solo practitioner were the two women lawyers who were practicing here, Bertha Douglas and T.I.O.N. Diggs. T.I.O.N. Diggs had preceded me from Howard Law School by about 2 years. I think she finished in 1948. And she came back, passed the bar, and joined Miss Douglas, and they formed a firm. But none of the others were in a position to hire or have an associate in their offices. So new lawyers would open their own solo practice, new minority lawyers. Of course, a lot of the white lawyers did the same thing, too, for that matter.
So is that what you did?
Oh, yeah, that's what I did.
And your office was located?
In the Metropolitan Bank, well, it's called Metropolitan Bank building, which was on the northeast corner of Church Street and Bramilton. And the building faced Church Street. In fact, its address was 700 Church Street. And that's where my office was. And my father had an office on the ground floor in that same building. He was on the Bramilton side. And there was at least one black lawyer who had been there many years in that same building who was very helpful, because you don't really realize how little you know till you start practicing.
Who was this attorney?
His name was Walter L. Davis, and he had been here since about 1918.
What were some of the things that he instructed you about?
Well, little things that they don't teach you. They don't have time to teach you all these details in law school, especially in a national law school. These are local rules, for instance. Every court has local rules. Usually they're written, and you go to the clerk's office and get a copy. And the mechanics. How do you file a civil suit? What is the jurisdiction of the court? If your amount in contest is above a certain amount, and you can choose whether you go into civil court or whether you go into circuit court. And just what I call the meat and potatoes. And how do you handle a preliminary arraignment in a criminal case, and so forth. And How do you handle discovery, which is very important, whether it's a criminal case or civil case. And of course, for a lot of this stuff, they're forms. You can buy the form books and so forth. But even after you buy your books, you've got to buy a code. Everybody has to have a code. This is before they had computers. And therefore, this stuff was in books. And those are the kind of practical things. You have a client who's been arrested. How do you arrange bond? Who are some of the bondsmen in the community? And these are what I call practical matters.
Were there any issues or ideas that he taught you about regarding black attorneys practicing in an area during that period?
Well, of course, you learn, or where you have someone who has been practicing, they frequently share some of their experiences. And if, for instance, at that time, some of the courts still maintained segregation in the audience. For instance, if you went down what would then have been, was called General District Court, but it would be traffic court. And that judge at that time instructed his court personnel, and that would be a deputy sheriff, that blacks were to be on one side of the courtroom and whites were to be on the other. Well, of course, we all thought that was purely unconstitutional, but thinking it and figuring out a way to attack it were two different things. And that was just practices in individual courts, practices of individual judges. And these are something that, unless you have been in a court, you don't know. And for instance, if you were going someplace in the area but you've never been there, one of the things that was expected on your first appearance would be that a fellow lawyer would introduce you to the judge. Now, the fact that you passed the bar and you're licensed, he doesn't know you from Adam. The clerk doesn't know you, or the clerk's staff. They don't know who the heck you are. You show them your bar card and so forth, but still, the custom was that you would get a lawyer who was already admitted in that court to introduce you to the judge.
Did you ever have a white lawyer do that, or was it usually a black lawyer?
Well, if you knew someone who was up there, black or white, that's who you would ask. And I've had it done by white lawyers, I've had it done by black lawyers. And but once you make 2 or 3 appearances in a court after you've been introduced, they know you. Black lawyers stand out because there's so few of you. So right away, they know you, but they may not know this white lawyer who's been there half a dozen times because he's just another white lawyer. And so you had high visibility.
Now, were there any judges in this area who were notorious for enforcing segregation policies, or perhaps being harsher with blacks accused of crimes?
There were some. There was, I mentioned this judge in what was now called General District Court. It had a different name at that time, but it performed the same function, which was to hear traffic matters and misdemeanor criminal cases. And there was a judge here in Norfolk who did that, and I'm sure there were others, say in Portsmouth or in Virginia Beach, because Virginia Beach didn't exist. It existed, but it was part of Princess Anne County back in those days. And so there were some judges who had a poor reputation among not only black lawyers, but among white lawyers, because if they had black the word got out pretty quickly if you had a judge who had a inclination to put heavier sentences on black defendants. That was not a problem just peculiar to our area. That was true all over the state. And one of the results, one of the things that happened as a result of these what we call sentencing disparities was the fact that the state, well, I say the state, but through cooperation with the Virginia Supreme Court, they had statutes passed creating a commission whose job was to design a fairer sentencing procedure. And because the problem was not limited to just states courts, you had the same problem on the federal level. And the feds, Congress passed statutes creating a commission that prepared what is known as federal sentencing guidelines. And of course, part of it wasn't necessarily always on a racial basis, but the problem of disparity in criminal sentencing was one that was fairly widespread.
How did this process evolve here in Virginia to establish these guidelines?
Well, I'm sure as the result of a lot of complaints. See, number one, it's very hard to appeal a conviction in Virginia. It's easier now, but then it was harder. The way our appellate system works, certain cases you have a right to appeal. But the bulk of cases, your right is conditioned on the willingness of the appellate court to hear your case. They want to control the number of appeals that they hear. And so in theory, they have this right, and in practice too, they have this right to determine, well, here is a case that does not raise any new issue, does not challenge the interpretation of some statute or the language in some statute. And we don't need to waste our time on this. So you don't get a motion, well, you make a motion for a writ which will allow you to appeal. And if they don't grant you the motion, your appeal is dead. And so it's very hard. The efforts to appeal were numerous. The successful appeals, that is just to get the court to hear you, were much smaller. And then the reversals were even smaller. So it was very tough.
So were you involved in getting that procedure changed?
Oh, no. An individual lawyer would have nothing, wouldn't have no input unless that lawyer was perhaps president of the Virginia State Bar or something like that, and the bar was proposing certain rule changes, which they do. That's part of their job. They have something called a council. And that council, from time to time, will propose changes in the rules and that sort of thing to the Supreme Court. And then the Supreme Court will consider and decide whether they will or they won't.
So who was responsible for getting this changed?
Oh, I haven't the slightest idea. I mean, I wasn't involved in it directly or indirectly. Number one, I didn't handle that many criminal cases. And unfortunately, most of the criminal cases that I handled, appellate issues were so infrequently raised that you seldom got an opportunity to even file a notice of appeal. Only you could file a notice, but to have a basis for going forward. And if you were court appointed, theoretically the state would pay for things like the transcript and the expenses. If you were retained, you had to have a client that was well-heeled because it could be very expensive. And way beyond just the attorney's fees. There were other expenses in connection with the appeal.
What were some of those other expenses?
Well, number one, you needed a transcript. To have a transcript, you had to have a court reporter. In Virginia, for a time, especially when I started, they didn't necessarily have a court reporter on felony trials. Only if you thought that some issue might be raised that you might want to appeal if you lost, would you, the litigant, go out and hire one. It is only in relatively recent years that they have that system. Was not a good system, was not a fair system, because people who were too poor to hire lawyers, obviously they couldn't hire a court reporter. And so that was unfair, and they changed that so that the state started paying for court reporters. But the system has gone through several changes now. In federal court, the system, they had staff court reporters there, and therefore they didn't have that problem. And now whether you could afford to buy a transcript was a different issue, but the government provided them there, and they had a record, and if you couldn't pay for it, then the government would pay for it once your indigency was established. But it just was a difficult situation, to say the least.
Well, now, in your earlier years in private practice, what were some of the cases or some of the kinds of clients you normally had, and how did you get these clients?
Well, number one, I didn't do much criminal work. I did some, but not much. I did more civil work. And for instance, I began to learn how to examine real estate titles, because people who were buying property needed to have the title examined to determine whether the people from whom they were purchasing the property had good title, were there any liens on the property, and so forth, because you could really get hurt if you didn't do that. So that was one area. My father, in addition to being a broker, bought and sold real estate for himself. And of course he had Walter Davis and one or two other attorneys that were doing his legal work. I came along, so I began to do some of it. He still had other lawyers because they were, you know, much more experienced. But this was a learning opportunity for me.
Okay. And so after how many years did your career take a different turn?
Well, I worked, for instance, I got on the court-appointed list for criminal cases. And from time to time, the court would appoint me on a criminal case.
How did you get on that list?
You went down and you asked to be put on a court-appointed list. They didn't have any test or any examination or anything like that. And they had certain practices. For instance, the court would not appoint you on a capital case if you had not had some previous experience with serious felonies and capital cases. And then they passed a statute on a capital case where the defendant was indigent and asked for an attorney. The court had to appoint two lawyers. And one of them usually was one who had had some considerable prior experience, and the other might not have had much, but this was their opportunity to start getting experience. Then I can remember Hugo Madison and I were appointed on a capital case. And this woman was charged with first-degree murder. They claimed she shot and killed her husband. And in any event, they had a pretty good case, and we, of course, were very diligent. We went out and tried to find witnesses. We visited the scene. Of course, we talked with our client who was in jail and that kind of thing. But it really was not, the Commonwealth had a pretty good case. And we tried this case before a jury, and the jury came back with, they didn't find her guilty of first-degree murder or second-degree, but they did find her guilty of voluntary manslaughter, whereas the prosecution was attempting to get a murder conviction. And in Virginia, where you have a jury in a criminal case, they, in addition to determining guilt or innocence, if they determine guilt, they are instructed to make a recommendation with regard to sentencing. And they do. And in this case, they recommended an 8-year sentence where this woman had shot and killed her husband. And we, of course, considered it a victory. Number one, she didn't get a murder conviction. Number two, the recommended time that the jury had recommended was much less. They could have recommended 20 years. But in any event, there were extenuating circumstances which we sought to put into evidence for the jury to consider. But it's just one of those things. There came a time when in 1960, President, well, he wasn't president, but Senator Kennedy ran for and obtained the Democratic nomination. Subsequently, he won the general election. He named one of his brothers as the Attorney General. That was Robert Kennedy. And he took over the United States Department of Justice. One of the things that he did is they began hiring black lawyers in the South. Now, they had black lawyers in D.C., and they had working for the Department of Justice, and they had some in the northern states, New York, Chicago, California, and so forth, but they didn't have any in the South. And that's when they began opening the doors to the United States Attorney's offices in southern states. And they got an opportunity to appoint one here in Norfolk, and my name was recommended, and I was appointed.
Do you know who recommended you?
Oh, sure. Victor Ashe recommended me, who was very active in Democratic politics at the time, and he was, of course, a black attorney here, and a white lawyer by the name of Frederick Stant, S-T-A-N-T. He was commonly known by one and all as Bingo, Frederick Bingo Stant. And Bingo was head of the city Democratic committee here, had been very active in Kennedy's presidential campaign on a local level, and would be the person who would make recommendations to, say, like the Department of Justice or other federal agencies when they were considering appointing people to positions in the federal government in this area.
How did you know Bingo Stant?
Well, he was, as I say, he was a lawyer. He was an active Democrat. He'd worked very hard in the campaign. And I had been one of the people working in the campaign on a small level. But I had helped in the efforts in this area to support and get people to go out and vote for Kennedy, because voting was a very tough issue. And we, at that time, as I recall, we still had the poll tax.
That was what I was going to ask you. I know that there was the poll tax and there was an anti-poll tax campaign. Were you involved with that as well?
Well, involved, I certainly supported it, and one of the things we did, there was organized in this area a branch of an organization that was headquartered in Atlanta, Georgia. And this organization's purpose was to increase the number of registered voters among blacks all over the South. And because in many areas the numbers were pitiful, if any, and second, especially in the more rural areas, and in many areas, persons who were seeking to encourage fellow blacks or blacks to register and vote put their lives in danger. And people down in Florida and Georgia and Mississippi and other places had been murdered in this effort to increase voters and voter participation. And I was active in this organization locally. We had like a state organization in Virginia, but the state organization was dependent on local groups, whether they were in Norfolk or Richmond or Charlottesville or Roanoke or Danville. You had local groups, and these local groups were usually made up of persons who were affiliated with local churches, persons who were affiliated with the local branch of the NAACP, persons who were interested in this whole problem of trying to increase voter participation.
What was the name of the organization?
I don't have a Norfolk Voters League. I don't know. Different places had different names. Up in Richmond, they had an organization, but I don't recall the name. Norfolk had an organization. What was it called? I don't recall it at the moment. But the Citizens Community Association, something along those lines. And
Go ahead.
No, I was going to say, in Norfolk, Victor Ashe was the head of the citizens groups. He had run for political office around about 1946, shortly after he got back from military service during World War II. The number of blacks who were registered voters was very pitiful. It might have been 2,000 in the whole city. And of course, he didn't win this election, but I have to add, there weren't a whole lot of people who even voted, white or black. But he didn't win, and it became perfectly apparent that you would have to do something about the number of blacks, because there were a great number who were old enough, who weren't registered, and who hadn't paid their poll tax, because you could be registered, but unless you paid your poll tax, you still couldn't vote. So that was the beginning of, particularly during that era, of trying to do something really affirmative about getting more people registered. And Victor was one of the spark plugs. And of course, there were other people in the community who worked very diligently on that. There was a black union, a man who was a president of a local union. And for reasons that can't identify at the moment, I can't recall his name. But he served as the president of the Norfolk branch of the NAACP. And he was a very articulate, very vocal, very diligent advocate of getting people to vote and register and pay their poll tax. And so it was a very, important era.
This was during the time, I believe, that Norfolk had the blank registration form.
Well, that goes back to the period of what I call, or what has been identified as massive resistance, as a result of the Supreme Court agreeing to hear these 5 school cases, one of which was from Virginia. One of the results was the majority of the Democrats in the General Assembly enacted a series of laws which have been described as massive resistance laws, designed to impede or stop, if possible, certainly impede, slow school integration. But at the same time, they were fully aware of these efforts at voter registration, and also efforts attacking the poll tax, because there had been cases, maybe at least a half a dozen cases around the South, because Virginia was one of about 13 states that had a poll tax. And that particular tax and its constitutionality was being attacked in a lot of these cases. None of them had won yet, but the handwriting was on the wall. Sooner or later, when you got a better Supreme Court, you're going to win some of these cases. But and they also knew about efforts at increasing voter registration. So all those were in the wind. One of the statutes that the massive resistance legislature passed was a statute which called for voter registrars to give persons seeking to register to vote a piece of paper upon which was printed the provisions of the Virginia Constitution that told the person what information they had to give to the registrar in order to qualify to register to vote. Under this statute, they directed the registrars to give this piece of paper with the instructions or the excerpt from the Constitution to the would-be registrant, give them a chance to read it and study it, take it back, give the applicant a blank sheet of paper, and on that blank sheet of paper, the applicant was required to answer the 10 items of information that were required in order to qualify to register. And of course, as soon as they did that, these voter registration groups, number one, they stopped taking people down to the registrar's office, but they started classes to instruct people as to how to provide this information, what the information was and how to provide it. Once the people were sufficiently trained, then they would take them to the registrar in groups, 5, 10, 15, and they'd tell the registrar, we don't want to see this form, just give us the blank sheet. As a result, anywhere from 90 to 95% of the blacks who sought to register, who had been to these schools, qualified. See, on this test, you had to be perfect. 100 was passing. If you got 90 or 95, you didn't register because you failed. And what was happening is whites who went down and seeking to register, not more than maybe 30% of them, at least on their first try, would be able to pass this test. So it wasn't long before they were besieging their legislators, and this particular criteria, this blank sheet law, was changed. And they went back to what was common practice in the cities. The registrars had a printed form, 1, 2, 3, 4, and the 10 questions were in with a space for you to answer them. This all arose because registrars in some of the smaller communities and in the rural communities number one, if you could find them, sometimes they're only there an hour a week, and if you had to practically sit on their doorstep to catch up with the registrar when his office was open. But in those rural areas, they would show you this portion of the Constitution, this printing portion, take it back and give you the blank sheet. But in metropolitan areas, Richmond, Norfolk, Charlottesville, and other cities, the registrars used this printed form, and they wouldn't take it back. You would be given an opportunity to answer the question. So the purpose of the statute, aside from delaying and reducing and the amount of blacks who could qualify, and to keep the number of people generally. They weren't too thrilled with new whites qualifying, but because the whole theory was to keep the pool of registered voters low. You have better control if the numbers are smaller. But that was the theory of the Byrd administration. In any event, that was the background of how this blank sheet law was passed and why it was passed.
So after you were asked to participate or to be appointed to this federal position, what happened after that? How long did the process take, by the way?
Oh, the process didn't take too long. I had to provide, of course, a resume, that type of thing, and then you had to go in and submit a fingerprint card to them, and then the FBI had to do their routine investigation because the position was in the United States Attorney's Office, but they did these investigations for a lot of positions, so they did a lot of this stuff. And then after they got back the report, and the then U.S. Attorney looked at it and the resume, and then he would pass it on to what we call Maine Justice, to the Department of Justice in District of Columbia, and somebody in the Attorney General's office was in charge of looking over prospective appointees to the United States Attorney's Office. And unless there was some glaring problem in either your FBI report or something, they really would pass it on back to the resident U.S. Attorney, and he would call you and let you know, and if that you were accepted and were you still willing, and you'd go in and sign the papers, and in due time you would be sworn in, and you'd get your official identification that they issued to people who are government employees, and you went to work.
What kinds of challenges or experiences stand out in your mind in particular once you began working in the U.S. Attorney's Office?
Well, number one, I was working in the United States Attorney's Office for the Eastern District of Virginia. Virginia was divided into two districts, Eastern and Western. The Eastern District had three offices, one in Norfolk, one in Richmond, and one in Northern Virginia in Alexandria. Now, theoretically, we had an office over in Newport News, but it was covered from Norfolk. And what happened is, at that time, there were only 5, well, actually there were 6, assistants in the Norfolk office. One of those assistants his specialty was real estate. But he didn't just handle it for Norfolk, he handled it for the whole Eastern District. So if the government was acquiring property in Richmond or anywhere in the state, in the eastern half of the state, it came under his bailiwick. The rest of us, the other 5 of us, since it was such a small office, we handled both civil and criminal work. That is, civil work and representing the United States, because people sued the United States, a lot of them. And civil also, United States was plaintiff in certain actions in civil matters. And of course, the United States was plaintiff in all criminal cases. And then there were the mixed cases where things arose in state court involving people who were government employees, and normally what arose was something related to their government work. And they, or their agency, would ask that the United States Attorney's Office represent this employee who was from the Postal Service or wherever he or she was from in this matter, because it arose out of their government work. So those were the three broad areas that we worked in.
Did you have any civil rights cases come before you?
Not much, very little. I was involved in the Norfolk school case, but what happened in that case was filed in 1957, and it came to fruition after a number of hearings in the summer of '58, and by that time the court entered an order directing the school board to admit 17 black youngsters to 6 Norfolk, 3 middle and 3 high schools. Okay, the United States government was not involved. That case went on for several years, in and out of court. The United States government didn't get involved till about 1970. It was the same case. Some of the names may have changed in the parties because the people graduated or what have you. But in any event, around about 1970, the Department of Justice, the Civil Rights Division, decided they were going to get involved in some of these school cases. Part of the problem was caused by the way the Supreme Court framed its decision in the school cases. And instead of directing these people to comply with the law promptly, they put in some very unfortunate language, something about all deliberate speed, and then turned over the interpretation of that language to local United States District Court judges. And what was deliberate speed in Virginia might not have been deliberate speed in Georgia or Alabama or Texas or where all these cases were. And as a consequence, especially in the South, defendants were doing everything they could to delay, impede, restrict the impact of the school integration ruling. And Virginia was one of them. This whole concept of massive resistance was just another tool designed to impede school integration. And it wasn't until about maybe 69, maybe 70, that the Supreme Court, some of these cases got back to the Supreme Court, new cases, and they began to make some decisions like there was a case out of North Carolina, and one of the aspects of the case, the court said that in fashioning a result, the court could use busing as a tool or require the school system to use busing as a tool. And then there was another case out of Virginia. I think Henry Marsh handled that case. Not Prince Edward County, because that was one of the 5 original cases, but there's a county a few miles south of Richmond whose name...
Chesterfield?
Who?
Chesterfield?
Oh no, it's too close. Different name. In any event, there was a very interesting case out of that. But basically what these cases were saying by the Supreme Court is that a district court judge could use and fashion different tools to expedite this whole desegregation process, and busing was one of those tools. And they also, for instance, there was a case out of St. Louis where, and this was decided by a black federal judge up there, where the court was directing the adjoining county and the city, and I don't remember whether it was St. Louis, I don't remember the city, directing the two school boards to work out a plan where, which might have provided for like a cross-jurisdictional busing and so forth. Now that case was lost. Supreme Court said no on that, and which was very unfortunate because that would have been another very useful tool, because one of the problems with so many of the white citizens, they had a problem called white flight. And whites were taking their children and moving out of the cities into the neighboring counties, suburbs, and because they wanted to get away from integrated schools in their cities. And if the Supreme Court had decided that case differently, that would have been a tool to fight white flight, but they didn't.
I want to kind of go back to this school desegregation issue and talk a little bit about your mother's involvement with that case. Can you tell me some of the earliest memories that you have of how your mother got involved and what really motivated her to be involved with this case?
Well, first, my mother was always interested in education. Secondly, when she returned here after living in New York for several years, and she returned here about 1944, one of the things that came to her attention was the results of these tests put on by the State Department of Education, which they did it in various grades, like third grade, fifth grade, and so forth, and on the middle school and high school level. But one of the things that these tests revealed was that many, many black youngsters, especially in the elementary grades, were scoring anywhere from 1, 2, 3 years behind white students in similar grades. And of course, my mother and a lot of other blacks, especially blacks in education, were very concerned about this. And that was one of the reasons she organized this interracial women's group. That was the first thing. And of course, she knew about, as a lot of people did, about the when the case arose in Prince Edward County, and was aware of its progress through the federal court system, and the fact that there were these other school cases, and all of seeking to attack segregated schools. When the Supreme Court decision came down, but even before, my mother had been working with other people like Dr. Marion Capps, who was on the faculty at Norfolk State. Her field, I believe, was mathematics, with especially in statistics in that area. And she was the person in charge of testing for Norfolk State, as I recall. And of course, she was not only familiar with the results that the State Department of Education was getting on its periodical tests, but all students who were entering Norfolk State had to take certain examinations and tests. And she knew from the results of these tests, a significant number of these students were scoring poorly in mathematics and in English particularly, and to a lesser extent in science, so that there were enough of them that they had to institute remedial classes for incoming freshmen who were scoring below a certain level because their preparation in the high schools they were coming from was not up to standard. So my mother was aware of all this. And she and Dr. Capps and a couple of other professors at Norfolk State, names will come to me, and some people who were either retired in the educational field got the idea that they needed to do something to assist the education of black youngsters. And one of the concepts or ideas was this after-school tutorial programs. And another was summer enrichment programs. And they put together an organization called the Norfolk Improvement for Education, Inc., the purpose of which was to do just what I'm talking about. They wanted to raise the horizons of these minority youngsters. They wanted to improve their skills in some of these basic education areas. Sooner or later, these schools were going to be integrated. But meanwhile, these children needed help, and they needed encouragement. And there was a need to lift their vision because so many of them were coming from homes with very modest backgrounds. Some of their parents were very poor readers. And they didn't have, or they had very minor aspirations. And what you were trying to do was lift their vision, encourage them to think big and to think broadly, and to give them some of the skills that would make that possible. So these were some of the things. And then when this Norfolk school case came along, the NAACP asked my mother to put together a school for the Norfolk 17, because when the governor took control of these 6 schools in Norfolk and wouldn't open them, it meant that there were 10,000 children, 10,000 white children, and 17 black kids who were out of school. Some of the white parents organized some sort of makeshift school for the white kids, but that only reached about 3,000 of those 10,000. And they were housed in churches because they had classrooms and so forth. And the teachers, all the teachers that would have been teaching in these 6 schools were all being paid, but they weren't going to work. So they volunteered to help out on these schools that the whites were organizing. In response to the NAACP's request, my mother organized this school for the 17 black kids. It was held at First Baptist Butte Street, historic First Baptist Butte Street Church, and they volunteered their facilities. And she recruited a faculty. And keep in mind, we're only talking about 17 kids. So some of the classes might have only had 4 or 5 kids at most in them. She also got books, all the textbooks for all the courses that they would have been taking. She got those from the Norfolk School Board, because there were some people over there who did not like what the governor was doing, but they were in no position to oppose it. But they certainly made the textbooks available.
Do you know who any of these people were?
No, I don't, but there were people over there who I'm sure were not supportive of the governor. Not a whole lot, but some. Mm-hmm. In any event, that's how the school got organized. And then even when the courts declared the statute under which the governor closed the schools, and those statutes were declared unconstitutional by the state Supreme Court and by the 3-judge federal court here in Norfolk, and the schools in fact reopened, there was still a ton of work to be done because the impact on school integration here was de minimis. Only 17 kids. 300 had applied for transfers, but only 17 had been ordered to be transferred, and the other 283 were not. And so this fight to integrate the schools was just beginning.
So tell me now, was your mother involved in the selection process of the number of students who actually did get selected?
Oh, no. What happened was Victor Ash, one of the local attorneys, J. Hugo Madison, another local attorney on that case, divided the children. 300 had applied to the school board to be transferred. The school board started putting up barriers. One of those barriers was that these children and their parents had to come in for personal interviews, presumably to assess their readiness or ability to go to integrated schools. I don't know what, but anyway, there was a barrier. Another barrier was I believe they asked them to take some sort of test. And there may have been some others, but those are the two that stand out. Well, the lawyers thought that anything that they didn't require white students to do was illegal and should not be complied with. But in order to test it, they divided the 300 students into two groups, one of 150 and one of 150. And Group A would do everything that the school board said do. If they said jump, they said how high. Group B refused to come in for interviews, refused to take tests. See, so now you've got two groups, and one you can attack the system, and the other you can still attack it, but you're attacking it from a different perspective.
Who created that tactic?
Oh, well, that was done by the lawyers, because this was done, that is to say, these school cases had been filed in a lot of areas. Virginia had several of them because Virginia had one of the better organized legal staffs under the leadership of Oliver Hill, Spots Robinson, and Martin A. Rotten of the firm of Hill, Martin, and Robinson. And they had cooperating attorneys in a number of cities in Virginia. But there were other suits being filed in each one of the southern states. And they had, of course, attorneys working on these things. And the attorneys would coordinate their tactics. And they were all, how shall I say, under the leadership of the NAACP Legal Defense Fund, which had handled just about all, well, they'd handle all the school cases, especially when the cases got to the Supreme Court. So they would exchange information and develop a common plan of action. But different areas had different problems. And because when people are dedicated to opposing something, they can get very inventive.
Were any of the local black bar associations involved in this?
Oh, not as an association, but individual members were, like Victor and Hugo Madison and James Overton over in Portsmouth, just to mention a few local. And there were some others, but those were the principal local ones.
Did any of these bar associations provide them with money or with any kind of support, or were they simply members of the association?
Well, they were members of the association, but in terms of moral support, yes, they were in favor of it. Just like in any legal problem, lawyers will frequently talk to other lawyers. They'll exchange ideas. They'll discuss concepts. They'll discuss the theory and so forth. But, and I'm sure a lot of that went on. But as far as any formal action by the Bar Association, no.
Did you experience any backlash when, because you were in private practice during the first part of this situation, did you experience any backlash from any of the judges or?
Not that I'm aware of. Number one, I did not handle a lot of litigation, so I wasn't in court that much. And for instance, J. Eugene Diggs, who was the oldest practicing attorney in this area when I came back and during this era, because he didn't die till about 59 or 60, somewhere around there. And he'd been here since 1904, or 1905 he started practicing. But he had a heavy criminal practice. I'm sure out of 5 days in a week, he was in court 3 or 4 of those days with some representing somebody. And his office was directly across the street from the courthouse on, I've forgotten the name of that street. But in any event, it was located where the Kern Memorial Library is currently located in downtown Norfolk. And so his experience in the courts would have been much more different than mine. He was there frequently. I might get there once a month. So there was no comparison. And besides, he was older than all of the judges sitting. Many of them hadn't even graduated from law school. Some of them weren't even born when he began practicing.
What about the, I understand that there were a number of lawyers who were being investigated by the FBI.
I don't know anything about that, but as part of the massive resistance statutes that the state legislature passed, they created a joint House-Senate committee whose sole purpose was to investigate lawyers who were representing clients in these civil rights cases, whether they were school cases or other civil rights cases. And the purpose was to harass lawyers and their clients. And one of the things they did, of course, they appropriated money to hire in staff and investigators, and one of the things these investigators did was to go out and interview the clients. And they would come to the client and say, how did you get involved in this case? Did the lawyer come and ask you to be a plaintiff or a party? And so forth. And of course, that's not how it happened. People who were members of the local NAACP, they would talk to other members or non-members and indicate they were thinking about filing a suit and were these people interested. But the lawyers wouldn't go out and talk to them. They have something called running and capping, which is an activity that lawyers are prohibited from engaging in. It's a violation of the codes of ethics. But it's where you go out, where the lawyer goes out and solicits clients, people who may not know him and may not even be thinking about filing a suit in a situation, but the lawyer would go out and say, hey, you just got involved in this terrible accident. Here you are in the hospital emergency room, and you've got a busted leg and your fractured rib, and this terrible person who was driving this truck or this other vehicle caused your accident. You need a good lawyer, sign here. That's a no-no. Mm-hmm. Instead, you send your ambulance chaser out there. Or you have somebody in the emergency room who steers people to a particular lawyer. There are many ways to get around that. But this legislative committee started harassing lawyers. And one of the things they did was, after they'd gone and talked to some of the clients, the committee or a subcommittee would come to your area and hold a hearing. And for the purpose of this hearing, they would issue subpoenas to the parties who were litigants and to their attorneys. And locally, that included Victor Ashe, J. Hugo Madison, and Slim Overton. Of course, they were doing this around the state. They were doing this to people in Richmond, Northern Virginia, people over in Hampton, Newport News, and other areas around the state, Martinsville and so forth. And of course, the lawyers refused to respond to these subpoenas. And litigation was filed attacking the statute under which this committee purported to act, and so forth. In due time, for instance, they would refuse to respond to the subpoena, then they'd go into a local court and file a motion to quash, because they would say that the subpoena is based on an unconstitutional statute and a legal purpose, and that they had no right to inquire about the attorney-client relationship and so forth. And that's how they fought these cases, but they wouldn't testify. And even when they went to a hearing, of course they'd identify themselves, they would challenge the constitutionality. People would ask them their name, they'd say, my name is so-and-so. Then they'd try to go beyond that preliminary question, and then they'd refuse to answer any further questions and state the basis of their refusal. So that was just another tactic designed to impede this whole process. In fact, they even got the state bar to go after some of the lawyers. Sam Tucker out of Richmond, they filed charges against Sam Tucker, and he requested a 3-judge court to hear these charges. And of course, that had nothing to do with the civil rights cases that he was handling. All of this arose, all in his situation, over a criminal case that he was handling in Lynchburg or someplace in that area. I've forgotten where it was now. But they had no basis. What they were accusing him was going around soliciting clients.